You were given a probation for this felony, and 4 months later, you picked up two new theft cases. You've had every opportunity for whatever help it is that is out there. It's not like you've just taken time and not had opportunities with probation to help you. And so at this time, in cause number 24, DC, excuse me, 24, DCCR 1778, I'm going to find that you entered your pleas of true, freely, and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property. Sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. Cause number 26, DCCR 0210. Find that you pled guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of theft of property. Sentence you to a term of 15 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in cause number 26, DCCR 0211, find sufficient evidence to find you guilty of theft of property. Find you guilty of that offense, sentence you to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These cases will run concurrently, which means together at the same time. I'm handing you the trial court certifications in each of those cases that shows that these were agreements that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. Right, ma'am, are you Kashonda Riley?
Yes, ma'am.
And so we've got three cases here for sentencing. Cause number 24, DCCR 1778, is a motion to revoke probation. Ms. Riley is on probation for theft of property with previous convictions. Entered pleas of true in that case. Let's see which counts.
I believe 1 through 5.
1 through 5, thank you. And then we've got two new cases, 26 DCCR 0210 and 0211. Ms. Riley entered pleas of guilty in each of those, which are theft of property with previous convictions. The agreement on all of these was for a cap of 15 months in the state jail prison. I've received the pre-sentence report. Have you both had an opportunity to review that report?
We have, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
Not from the defense.
Nothing from the state, Your Honor.
All right, Mr. Rojas, you may proceed.
Thank you, Judge. I know it's a big ask, Judge, and it's not something that the court, I think, probably is leaning toward, but we're asking the court to consider probation in all these cases. Ms. Riley is 27 years old. She's got two young kids at home. As you can see from the PSI, most of her previous offenses are theft or some type of deception cases. And certainly she's old enough to know better. She should know better. I think if you look closer at her background, it's a situation where she never really had a chance to get any kind of direction in her life. She was placed in the CPS custody when she was 3 months old. I think she lived with her aunt until she was 14. I think all that time, or most of that time, her mother was in prison. And when her mother got out of prison, Ms. Riley went back to live with her mom. From 14 to 17. At 17, she ran away from home. And I think her father's in prison now. I don't know how long he's been in prison, but he's in prison now. I think the easy thing to do is to go ahead and send her to the state jail. Not only for the court, the easy thing for Ms. Riley would be to send her to the state jail so that when she gets out, her slate is clean. She starts all over. I don't know that that's going to, I think if that happens, Judge, she's probably going to be back in the same place she's at, committing offenses, committing more thefts. What I'm asking the court to do is consider probation with possibly ISF, the cognitive track of ISF, so that she can get some direction, hopefully start learning how to make better decisions, and get her life onto the right track. And I think, do you want to say something to the judge?
Yes.
At the appropriate time, she wants to say something.
Go ahead.
No, I have had time to sit and think about my consequences. I I have talked to my aunt that I was staying with at first. She said that I could come back to stay with me and my two children. She's willing to help me try to get a GED and to get into the infirmary and the plant, like the refinements. So
You need to look back. The NTRP case for me. How long she said? All right, Mr. Nichols.
Judge, I think the 15 months is appropriate in this case. Her misdemeanor history is incredibly extensive, lots of thefts, lots of probations that have been revoked. And if you follow the timeline, it's for committing thefts while on those probations, which is what she did here. Two new thefts, 6-7 months after being placed on probation for theft. So I think given her criminal history and continuing to commit crimes while on probation, I think 15 months state jail is appropriate.
Give me just a second. I want. Yeah. And if that's not easy to find, then.
What's the question, Ron? I might know.
To this case?
No, I'm wanting to know, and it's not really gonna make a big difference, but she said she's had time to sit and think, and what I wanted to know was how long she had to sit and think before she took the probation on the case she's on right now.
I can go back and look it up if you need it.
But so Miss Riley, you were on probation. You've had 1, 2, 3, 4, 5, 6, 7 probations. 7. A real easy way for you to stop being incarcerated, and that's to stop stealing. You can't expect to keep doing the same thing and not have more harsh consequences. And so you need to understand that when you get out of state jail, if you do this again, it's going to get worse every single time. So if you want to be there for your kids and break the cycle, then that's going to be up to you to break that cycle. All right. Go back with the bailiff. Charles Verdine.
Carlson, A.
Charleston A. Verdine. Charleston A. Renee Verdine.
You had Charles Verdine.
we've already met.
I have. This is okay. This is. Charleston.
Got all the birthdays.
Mm-hmm.
This is not.
It's different. Welcome to it.
Yeah. Well, good morning, ma'am. Are you Charleston A. Verdine?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
And Judge, the reason for this offer, if the court is inclined to follow it, just so you know, the motion was actually filed 10 days before she was set to expire out completely. So we're just trying to double back and address the addiction issue.
All right, Ms. Verdine, in cause number 22-40028, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 25th of 2023 for the 3rd-degree felony offense of obstruction or retaliation, and that was a 3-year deferred probation. Is that correct? The motion alleges that you violated your probation. Is that 1 through 5?
It is, Your Honor.
Count 1 alleges that you provided a urine sample June 26th, October 15th, and November 17th of 2025 that tested positive for tetrahydrocannabinol. And is that true or not true?
This one. True.
That's marijuana.
This one. True.
Okay. Count 2 alleges that you failed to successfully complete the GED program as directed. Is that true or not true?
True.
Count 3 alleges that you failed to abstain from the use of any and all intoxicating substances, including alcohol, and that you tested positive for alcohol June 26th and October 15th of 2025. And is that true or not true?
True.
Count 4 alleges that you failed to submit to alcohol or drug screening October 14th of 2025. And is that true or not true?
True.
And then count 5 alleges that you failed to successfully complete the moral recognition therapy program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those because they're actually true?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for me to continue your probation and extend it for 2 years. Order that you enter and successfully complete the JCDI program, which would also include a drug patch. Is that your understanding?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted any evidence that Ms. Verdine is not competent.
Oh, yeah.
So I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I do want to get an updated report. So we need to figure out between now and then what I can do between now and then. I just want to make sure that probation also agrees that that's all of the treatment and everything that's necessary. I'm willing to set a bond, and she's on probation. She can go ahead and start those programs, but I want to make sure, I think that we're covering everything, if that makes sense.
Judge, she's been incarcerated for a while. Would the court consider a PR?
Yeah. So, okay. So what I'm going to do, Ms. Verdine, is I'm going to reset your case for sentencing. I'm not going to sentence you and extend it today. We're going to do that later. But I am going to reduce or set a bond for you in the amount of $1,000, but make that a personal bond, which means you don't have to pay any money. You're just going to get out of jail.
Yes, ma'am.
You're still on this probation. You're required to do everything, including starting that JCDI program. You have to have a drug patch on within 24 hours of your release from custody.
Yes, ma'am.
If you don't do that, I don't have to go along with this agreement when you come back. If you test positive between now and then, you're going to be right back in jail. Do you understand?
Yes, ma'am.
You can talk to your probation officer about where to get that drug patch. They'll help you with that, and then we'll see you back at sentencing. Okay.
Yes,
All
ma'am.
right. You can go back with the bailiff.
I have a question.
Hang on just a second.
Is the drug patch right now just gonna be a condition of a bond? Or,
It's going to be both.
okay,
It needs to be a condition of probation and bond. Yes, ma'am.
I forgot what I was saying.
Sorry.
So I forgot.
Okay. If you think of it, Mr. Rojas will be around. You can tell one of the bailiffs. All right. You can go back to the bailiff.
Judge, may I report?
Yes, ma'am. In just 1 second. Let me write this down before I forget. Yes, ma'am.
Eli?
That Judge, I'm understanding he's on vacation this week.
Okay.
So if we could reset 1 week, he said he'll be back Friday, so.
Let's reset it 2
And
weeks.
he's hired misdemeanors.
Let's reset it
Not
2
out,
weeks.
But really one is the big. So. To actually still in this, but Altman has to plead him on his misdemeanor.
On Daniel Eli, we're going to do 2 weeks, because if we just do it a week, he's not going to have time. And if he goes and takes care of it, you can just dismiss it without him coming back here. Okay.
Yes.
Okay. That's Daniel Eli.
Yes, ma'am.
And then Anthony James.
Yes, Your Honor, if we've received an offer, an adjusted offer, if we can have like just 2 weeks or so for him to get with his family, it's a TDC.
Okay. We're going to reset, we'll reset James a couple of weeks. Mr. Lewis, you have 10 fam? Are they all state jails?
Yeah, sure.
Enhanced at all?
No, I think he has, Anything done hands-on.
Yeah, I don't think so.
But they're stackable.
Those are all different dates.
Yeah, yes.
And y'all talked about that?
Yes.
Okay. Good morning. Are you Tan? You're Tan Van Pham?
Yes, ma'am.
And Mr. Pham, you are charged in cause number 25 DCCR 0909 with the state jail felony offense of theft of property from May 3rd of 2025. If you go to trial and you're found guilty, the range of punishment is between 6 months and up to 2 years in state jail prison. Do you understand?
Yes. Depend on my lawyer. If she say yes, I have to say yes, ma'am.
No, I want to make sure you understand. And do you understand? Do you need an interpreter? Would that be better?
Yeah, that's better because I don't understand English very well.
Well, we've been able to communicate,
You have
you know,
the whole time.
Yeah, yes, ma'am.
So, Mr. Fan, if you go, I just want to make sure in all of your cases, every single case, you've got 25 DCCR 0909, 25 DCCR 1039, 26 DCCR 0353, 54, 55. And then we've got 25 DCCR 0782 and 0785. All of those cases charge you with theft of property with previous convictions, which means if you're found guilty, the range of punishment, you could go to prison for a minimum of 6 months up to 2 years in each of those cases. Do you understand that?
I know, but I don't do like that, you know.
I just want to make sure you understand that
Right.
if a jury finds you guilty, what the range of punishment is, what could happen?
I don't know what it means because my English not too well, you know. But I don't do like
We're
that.
gonna reset it 1 week. Let's get, figure out who we can get as an interpreter, please. You speak Vietnamese?
Yeah, I speak with them.
Okay, we'll see you next week. We'll figure it out.
Okay, thank you, ma'am.
Yes.
Thank you so much.
I don't know, yeah. And then Mr. Rojas, Justice Lars,
Yes, ma'am, he wants to talk to them.
he wants to do what?
Talk to the court again. He wouldn't.
Let's get Mr. Larzo out real quick, please.
Maybe if I lick you off, it'd be very, that's what it is.
You see like the price is right. Remember that game the little guy goes.
The mountain climber.
Little mountain man's going.
There's so many words are allowed. Yeah. All right, Mr. Larzo, what's going on?
I'm going ahead. I want to request a new lawyer. He's not representative.
Here's the thing, you don't get to do that. So here's where we are. Mr. Rojas is a great lawyer. He's not, just because
Can I
he's,
speak?
nope, not while I'm talking. I already gave you an opportunity earlier and I'm gonna give you an opportunity in a minute, but I want you to listen carefully to what I have to say first, okay? Mr. Rojas is telling you what the district attorney's office is offering. You don't have to like it. It doesn't mean he's a bad attorney. And another attorney is not going to come get a different offer.
Okay.
So, Ms. Malfino, is there any reason that you would know of that offer that you have made would change?
No, it will only go up.
So you're where you are. So either you accept that offer or we set your case for trial. Once your case is set for, hang on,
I want a new lawyer. I don't.
hold on.
You
I understand, but listen.
want to let me speak, man? Please, can I speak? Please?
I'm going to let you speak, but I'm going to give you what your options are, okay?
I just want. All I want is a. What I'm saying, you trying to say trial, this and that. I haven't even seen my discovery evidence. You saying he's a good lawyer, but he haven't even shown me no evidence. So on my case, how can you speak and say he already told me the other day that he working for the DA? He
I'm
already said,
sure
when I said you haven't, he have not one asked me what happened. He haven't even got my side of the story. Have you got my side of the story? Have I told you what happened in this case? Can you tell this person what I told you?
Mr. Larzo, you're not in charge and you're
I'm
not
not saying
asking
I'm not in
questions.
charge, but what I'm saying is, how can he say he can represent me and he's ain't done nothing but come to me and say the DA said this, the police report said this. He has not.
That's the evidence. That's what he's telling you the evidence is what's in.
That's what the police report said, but he hasn't asked me my side. It's a.
And here's the thing, your side is important if you're gonna, if you didn't do it, what his job is to tell you, this is the evidence they have against you. You can take this deal, or if you say you didn't do it, you can go to trial. So if you're saying you didn't do it, then let's get a jury to determine if you did it or not.
I haven't seen no police report. I haven't seen no body cam footage. I haven't seen no evidence to where I can tell you if I'm ready
Is
to go
there,
to trial.
is there media in this
Judge,
case?
if, as Mr. Rojas does in every case, he has requested and reviewed the discovery well in advance.
Do you want, let's do this. Do you have some media?
Judge, I have requested the media, what I told Mr. Larzo yesterday, when he told me he wanted to watch the video, I told him we could reset the date to look at
Sure.
the video. He just said he didn't want to do that. He just wanted to come in and ask for a new lawyer.
I want to because you now represent me effectively. You come to me and tell me the DA said this.
Mr. Larzo, he's just said that yesterday he would bring the video. Don't talk over me. He would bring the video for you to watch. I'm going to reset your case for 2 weeks. He's going to bring the information. You can watch it and you can make your decision. The offer is what the offer is. The DA's already said that. I don't care if you take it or if you don't take it. Take it, fine. Don't take it. We'll get your case set for trial. You need to be respectful. Mr. Rojas is going to get out there, show you everything. You don't get to keep copies of things by law. He doesn't get to hand you a police report and you keep it. That's part of the law. So he can go over that with you, read what it says to you, show you the video, and then you can make your decision. Go back with the bailiff.
When I ask a question,
Go,
please?
nope, I'm done today. Go back with the
I'm not
bailiff.
understanding how you
Let's
can
go.
give somebody 4 years for an aggravated charge
Let's go.
and try to offer me 5 years for non-aggravated.
Let's go.
So he's not happy with this.
DeMarcus Elam, wait, hold on, Mr. Burbank, what are you doing on, Mouton?
Hi, Mr. Mouton,
I know, what's the announcements?
I'm still in discovery. I just got appointed and I've talked to her. I think also based on that, I may need to have her evaluated somewhere between here and there. My request, based on the circumstances.
What?
Evaluate.
Somewhere between here and there?
Yeah, well, my motion is here between here and there. The evaluation. It's coming,
Okay.
like today or tomorrow.
Okay, we'll reset Ms. Mouton.
And I've talked to her. She knows what's going on and
All right, yeah, if you'll make sure you get that in,
She's
we
happy.
will get her, evaluated as quickly as possible.
maybe I can convince Mr. Smith to.
DeMarcus Elam,
Just
yeah, DeMarcus Elam. Mr. Smith, you've got DeMarcus Elam, written hearing. Good morning. Are you DeMarcus Elam?
Yes, ma'am.
And this is cause number 26, DCCR 1221. Mr. Elam is charged with the first-degree felony offense of murder. And Mr. Reynolds was appointed as attorney. Ms. Holmes is stepping in to help out on that as well. And they have filed a writ requesting for a reduction in Mr. Elam's bond, which is currently set. Oh,
Yes.
Oh,
Yes, I believe Mr.
did I
Elam.
know that ahead of time?
Okay. He was from the book that he. I'm sorry if I didn't make that clear.
No, I guess not, because I'm not gonna, so here's the thing, when you have an attorney, you don't get to have what we call dual representation. So if you, and I don't mind,
I think if I could clarify, it was filed pre-indictment. I'm not sure when Mr. Reynolds was placed on it, but Mr. Elam had filed the writ prior to being indicted, and then after the writ was filed, his case
was indicted.
was indicted.
So it's been indicted at this point.
Yes, ma'am.
Okay. So here's what I'm going to do. What's the bond currently set at?
2 million.
Okay, so what I'd like to do, I'm not going to, because the case has been indicted. At this point, a writ is probably not the appropriate, tool. I would think it would just be a motion for a bond reduction. Ms. Holmes can talk with Mr. Reynolds. They can get that filed. They're going to file things on your behalf, okay? And so I understand that you were waiting on an indictment but that's been taken care of now. But you don't get to file something if you have an attorney. I'm gonna take what they filed. So let's get a bond reduction. Ms. Holmes will get that filed for you. I'll reset the case 1 week, but I think we need to have the appropriate tool moving forward legally. Let's do 2 weeks, and we'll have a bond hearing. If the state has any evidence, that'll give them some time to bring anybody if you wish. Well, they said something about they would lock open the bench. So apparently they have access to do something to open and close the bench.
Thank you so much.
I don't know, but I mean, that's what I said. Well, I've got the thermostat that's down, but it's going up. And I heard them saying in the background, okay, well, we'll do something with the vent. But now it is chilly, but I'm not gonna complain because. See, Mr. Parker, you've got Edward Godfrey. It's a sentencing.
Edward Godfrey.
Who? Oh. Good morning. Good morning. Are you Edward Godfrey III?
No.
And Mr. Godfrey was previously here in cause number 26 DCCR 0383. Entered a plea of guilty to assault family violence by impeding breath or circulation. I've received the pre-sentence report. Have you both had an opportunity to review that report?
Yes, ma'am. Yes.
I'm sorry.
Yes, Your Honor.
Are there any additions or corrections?
None more, Judge. Nothing so.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 6 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. This is such an excellent opportunity for you. You're very young. You do not want a felony conviction on your record. It'll change your life in a very negative way, in lots of ways. You can't go to obviously certain jobs, schools, apartments, it just all kinds of things. And so part of your probation is going to be that you get your GED or finish school, one or the other. So if you're not going to go back to school, then you have to start that GED process within 30 days of today. That's not just for me, that's for you. That'll make it also everything in your life easier, getting better jobs and things like that. It's very important. It should be important to you. So I want you to get that done. You're going to go through some classes. You're going to do everything you're supposed to. Then at the end of your probation period, if you're successful, the case is actually dismissed. You never have a felony conviction. The other side of that, though, is if you do violate any condition of probation, you can be brought back into court, found guilty. So you would be a convicted felon and you could go to prison for up to 10 years. Do you understand?
You good?
You understand? And also, it is a condition of your probation that you have absolutely no contact, communication in any way with Ramsey Howard. Do you understand? Okay. All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. All right, good luck to you. You can go back with the bailiff. Marvin Watts, Mr. Parker.
Good morning, Your Honor.
Good morning.
Mr. Parker.
Do I have,
He signed on your spot on one of, but I'm just fixing it.
in both cases or just one?
Just one.
He's paying on both cases. He signed.
He just signed one spot.
Oh, because I don't see any here yet.
Yes.
Okay.
Listen. Oh.
All right, sir, are you Marvin Lee Watts
Julie.
Jr.? And Mr. Parker, will your client waive the formal reading of the indictment in each case?
That's Sharon.
Mr. Watson, cause number 25, DCCR 1918. You're charged with the first-degree felony offense of aggravated robbery from October 2nd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? And then in clause number 26, DCCR 0946, you're also charged with a first-degree felony offense of aggravated robbery. This is from September 12th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And because you did what they charged you with? In each of those cases, I have here on the tablets documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand if I follow the agreements that you've made with the district attorney's office that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached in each of your cases is for a cap of 17 years in prison, which means you're leaving your punishment up to me. I can give you 17 years. I can give you less. It'll all depend on the information that's brought to me at a sentencing hearing. You have every right to have a jury come in and decide 2 things. First, to decide if you're guilty or not. And then if they find you guilty, you could leave your punishment up to that jury. If we go forward this way, you're waiving that. And is that what you want to do? So you have, what you've agreed to is a cap of 17 years, which means a cap, all that means is that you're leaving your punishment up to me. And you could, if you wanted, have a jury decide instead of me. But if we go forward this way with the papers that you've signed that says that you're waiving a jury and that you want me to sentence you within that range of punishment, which would be between 5 years up to 17 years, there's the possibility of probation. It'll all, again, depend on what information I get when we come back for sentencing. And is that what you want to do? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
Objection.
It's admitted in each case. Is there any evidence that Mr. Watts is not competent? All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas, find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases for when we come back for sentencing. Anything that you think is important for me to know, make sure you get that information to Mr. Parker. He'll present it to me on your behalf. Okay.
Yes.
Right, you can go back with the
Thank
bailiff.
you, Judge. Thanks for getting me in.
Yes, sir. Mr. Macon, you have Cyprian Avedontu. Yeah,
That's what, Your Honor.
it's not even close, I'm sure, but. Avedonte.
Romania. What's the name, Judge?
Cyprian Avedonte.
You got it.
You didn't want to relay that? Good morning.
How you doing?
Welcome. I just realized now that I'm reading on, I'm noticing that they're backwards. What's that? No, they changed it and she's getting it changed back. Yeah. Good morning.
Good morning.
And are you Cyprian? Is it Avedonatue?
Yes.
Close enough. All right. And Mr. Avedonatue, I can't say it. Is charged with unlawful interception or use of a wire oral electronic communication. And Mr. Macon, what is the announcement?
Yeah, and I'm gonna call him Cyprian. He just got back here from California. He was in custody out there and they brought him back. And Pam was just appointed on the case. And I really haven't got with her to discuss all the things. Plus, I have a Romanian interpreter interpreting quite a few papers that show my client was out of the country, but I would ask for a normal resetting.
Okay.
I'd work on all that.
All right. And Ms. French, any issues with the
No,
reset?
I've been given a thumb drive with information on it and I'll be reviewing that as well. So I appreciate the reset.
All right, we'll just do a normal reset and then we'll see where we get the next court date. You can go back with bailiff. Mr. Kelly, you've got Dalton Batiste.
Judge, that's Mr. Coleman's hold on to that case. Can you hold it just for a minute? He knows Mr. Kelly's here.
Sure.
He's gonna come up with it.
Thank you.
Thanks.
I'm waiting needed.
Not yet, I'm sorry.
Not at all. Thank you very much. Thank you very much. Very well.
See, Mr. Lewis, you've got DeJuan Banks.
Yes, ma'am.
DeJuan Banks.
Right.
No. It just was amazing. And
Morning. How are you, Mr. Lewis?
I'm doing all right. That's fine.
Good. Good morning. Are you DeJuan Banks?
Yes.
And Mr. Banks, in cause number 25 DCCR 0990 is charged with injury to a child, elderly, or disabled individual. What is the announcement?
Well, Judge, when last setting he was here, I think it was some issues where the state was trying to locate where what placement where the child was, so we try to move this case along. We have since found that information out recently. He is out of state. So I know now they're
Judge, if it makes sense to you, and Mr. Lewis has been nothing but helpful to me. And we have talked about different offers that one would expect would resolve the case if guilt was really on Mr. Batiste. What I'm trying to do is find
Banks.
Banks. Sorry, I'm sorry. I'm 30 seconds behind. Sorry about that. If that makes sense what I'm saying without saying it out loud. The child is in the custody of family members under the care of foster care. So when I look from everything I have access to, it looks as if the child is in the care of foster care, which is where I have been going to try to locate and put people to speak with. But now the child is in foster care, but with the family, if that makes sense. And I wouldn't know this information but for Mr. Lewis.
which is now who I need to speak with. I know it says final. If we need to put it on the trial market, obviously that will be done well in advance of when that trial market would be. That's
No, I guess
Just
you're
so
saying
issue-
you now have, you know where you.
yes.
Okay.
Even though all the logistics say foster care, the child is still in foster care, but is with the
Okay.
grandparent.
I'm gonna do one more reset to give you some time to get a visit with them, and then let's get an announcement at the next.
And they have been generous with that information. Otherwise, I wouldn't know where that child is other than through the foster care system. That he's not a possessor of custody, so to speak.
All right, thank you. You can go back with the bailiff.
Thank
Thelma Gilbert.
you.
Good morning. Are you Thelma Gilbert? Answer out loud, please. And this is cause numbers 26 DCCR 0502, 03, 04, 05, 06, 07, and 08. Miss Gilbert is charged with credit or debit card abuse in 4 of those cases, burglary of a habitation in a case, fraudulent use or possession of identifying information, as well as theft of property. And what is the announcement?
Judge, we've gotten a offer that will probably resolve this matter. It's going to involve a lengthy prison sentence. Our issue right now is day before yesterday, Miss Gilbert's daughter and her father were involved in an auto accident, and they're being hospitalized in Dallas. So we're trying to find out, I guess, status of exactly what's going on with them. So she'll know basically the stability of a daughter before we do the agreement. So I'm just asking for a short setting so we can get that resolved, so we can move this case along, Judge.
I told Mr. Lewis I would hold that offer open if we got a reset for that reason at 89.
All right, I'll reset it one time for that.
Thank you,
You
Judge.
can go back with the bailiff.
Thank you.
Pham,
Judge,
Mr. Lewis?
hold on that one.
Sure. Thank you. We'll hold that.
Hold on.
Um, Justin Thomas, Mr. Lewis? Competency.
Yes,
He's confident now.
yeah, we just got that.
Okay, so you'll just need some time.
Yes, ma'am.
Let me make this finding of competency and then
And I need to look into it. Some kind of while he was in the hospital there, I think he got a PR bond on one of the cases. I'm just trying to make the check, see where that even came from. He gave me the paper. It's just one.
Kelly, can you make a note to look into that? Yeah, please. All right, sir, you Justin Thomas? And I'm going to take judicial notice of the court's files and cause numbers 25 DCCR 0308 and 25 DCCR 1874. Mr. Thomas was previously found not competent to stand trial, was sent to the John Dunn Behavioral Science Center for Competency Restoration. I've received that report dated June 16th of 2026. It includes the trial competency evaluation report, which is prepared by Dr. Guzman. The findings in that report is that he is currently competent, has achieved competency while he was there. Also in that packet is the attending physician's report to the court, and that is dated June 15th of 2026, prepared by Dr. Liberis, again with the finding that Mr. Thomas has achieved competency and is currently competent to stand trial. Is there anything else with regard to competency?
No, ma'am.
Then at this time, I am going to find that Mr. Thomas is competent to stand trial. My understanding is he just got back here from John Dunn, and so I'm going to do a normal reset. That'll give you
Yes.
some time to visit with Mr. Thomas about any options he has on his case. All right, so Mr. Thomas, Mr. Lewis will be out to see you very soon to go over everything with you, okay? All right, we can go back with the bailiff.
Thank you.
And then you've got Jason Weinberg, it's the sentencing.
That's right.
Weinberg. Weinberg, that's Weinberg.
Smart for them. Yes.
Good morning, you're Jason Weinberg?
Yes.
And Mr. Weinberg was previously here and entered a plea of guilty in clause number 25, DCCR 1479, to the state jail felony offense of engaging in organized criminal activity. I've received that pre-sentence report. Have you both had an opportunity to review the report?
Yes, Your Honor, we have.
Any additions or corrections?
No, Judge.
Not from the state, Your Honor.
All right, Mr. Weinberg, I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings. You'll be placed on probation for 5 years. You're ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation.
Yes.
If you do that, this is a great opportunity. You're very young, you don't have a felony conviction on your record, and if you successfully complete this probation, you'll never have a felony conviction. At the end, the case gets dismissed. It's a
Yes.
great opportunity. The other side of that, though, is if you violate any condition of probation, you can be back here in court, found guilty, so you become a convicted felon, and you could go to the state jail prison for up to 2 years. Understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. Probation will talk to you probably before you leave. Good luck to you, sir.
Thank you.
All right.
Thank you, Your Honor.
Thanks.
Judge, no,
No.
I'm sorry.
I said for next.
Mm-mm. No, that was, we'll see. Since it's a state jail, she said no ISF for
Oh.
him. I said, no, we'll hopefully not need that.
Not too bad.
So, that DeMarcus Evelyn is gonna be Brittany handling that.
Yes.
And that's for a bond.
Yes.
Okay. Hi, good morning.
Urban County, so Tom, I can do a cooking song. I was gonna take one back where you think that will have to do.
It is on Dalton Beach. Okay,
And congratulations.
I know, thank you.
Okay, y'all have a great day.
Thanks, you too. Let's see. I know, usually he at least stops by. Ms. Holmes, are you ready on Daniel Eli?
You may be a pro on
Autumn's supposed to plea on, Autumn has his misdemeanor.
Oh,
She's
okay,
supposed to plea on the misdemeanor so that will dispose of the felony.
okay,
Can't find Autumn.
okay. Well, I'll hold it.
Okay.
Is he supposed to do it today?
Yeah.
Yes, they've always been set together.
Yeah,
It's been trying to get it all of the parties here.
okay.
And if
I'll hold it and
push comes, to shove, Judge, I can do that today, if you allow me for the record, that if that does not.
and that's fine if we need, I mean, I can just reset it a week and then get them down there this week, but
Yeah,
maybe,
it just keeps going back and forth. I think.
yeah.
Unless they let me, them, step in, if they let step in and they rest in.
See if you can get, y'all have already tried to call Audwin this morning.
I have not.
See if y'all can get him on the phone, and if he's around, great. If not, see if he'll give you permission to do that.
Okay.
I'll hold it for now, though.
Oh,
And then you've got Janaea Fine.
yes, sir. Please. Yeah, that's the other one. At one, she should make another copy of.
Oh, okay. Thank you. And this. Good morning. Are you Janaea Fine?
Yes, ma'am. Yes, Your Honor.
And will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Ms. Fine, in clause number 26, DCCR 0432, you're charged with a second-degree felony offense of assault on a peace officer from January 13th of 2026. And how do you plead to that charge?
I plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And are you pleading guilty because you did what they charged you with?
Yes, Your Honor.
And then we have clause number 26 DCCR 0433. And in that case, you're charged with a third-degree felony offense of harassment of a public servant. And that's from January 13th of 2026. And how do you plead to that charge?
I plead guilty.
And are you also pleading guilty in that case freely and voluntarily?
Yes, Your Honor.
And because you did what they charged you with?
Yes, Your Honor.
In both of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, Your Honor.
And it looks like the agreement that you've reached in each of your cases is for a 5-year deferred probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, Your Honor.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. Fine is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of guilty in each of your cases freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. Find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we'll come back later for sentencing. Before we talk about the bond, there is only a fine in 0432 of $500. There's no fine in 0433. And so, Ms. Malfino, what's the state's position with regard to
No objection.
a bond? So, Ms. Fine, what I'm going to do in each of your cases, based on the nature of your plea agreements, is reduce your bond in each case to $1,000. I'm going to make those personal bonds, which means you don't even have to pay any money. You're just going to get released from jail today. But there's some very, very important things that have to happen between now and when you come back for sentencing if you want me to go along with this deal. The first thing is that when you are released from custody, the very first thing you do is go to the probation department. You're going to get some papers today. It's going to tell you where to go. So you have to go straight there so they can start that process to get that report from me, okay?
Okay. Yes, Your Honor.
If you don't do that, then obviously a warrant could go out for your arrest. I don't have to follow this agreement. Things could be a whole lot worse. So it's very important that you do that, okay?
Long as the address on it, Yana, I'll go.
The address will be on it. You'll talk to a probation officer in the courtroom today before you leave, and she'll tell you everything you need to know about where to go, okay? The next thing is that you cannot get in any trouble or arrested for anything between now and when you come back. If you get arrested for anything, you run the risk of me raising your bond, or you'd be back in here and I don't have to follow this agreement. You understand?
Yes, Your
All right, you can go back with the bailiff. We'll
Thank
see
you,
you at
Your Honor.
sentencing. Anthony James, Ms. Holmes,
You can hold that one
Sure.
for 1 minute.
and then what about Michael Spain?
It's a testimony.
Mr. Kelly, are you ready to announce on Dalton Batiste?
Yes. Oh,
All right, so you're Dalton Batiste. Answer out loud, please. And this is clause numbers 25 DCCR 1436, 1437. In each of those cases, Mr. Batiste is charged with manslaughter. And then in 24 DCCR 0407, charged with possession of marijuana. And what is the announcement?
objections to the court, Judge.
Go through that. Sorry, I didn't. All right, so Mr. Batiste, in each of those manslaughter cases, the range of punishment if you're found guilty by a jury, that's the state jail. Sorry, I had the wrong one pulled up. 4 seconds, correct?
Yes, Judge.
Is between 2 years and up to 20 years in prison in each of those cases. And then in that possession of marijuana case, if you're found guilty by a jury, the range of punishment is between 6 months and up to 2 years in a state jail prison. Do you understand?
Yeah, yes.
And I have here on the tablet some plea bargain rejections that you've signed with Mr. Kelly that shows that the district attorney's office has made offers if you wanted to enter plea of guilty for 10-year term in the manslaughter cases
I don't think we sent a third one, Judge. We didn't.
with, I guess, something on that state jail that would run concurrently with that. So it would be 2 10-year sentences, but they would run at the same time. And then whatever you got on the state jail would also run concurrently or at the same time. You have every right to reject those offers and have all of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. And do you understand all of that? And do you want to reject those offers and have all of your cases set for trial? All right, we'll get them set on the trial docket, and Mr. Kelly and Mr. Kurtz will get them in preparation for trial. You can go back with the bailiff. Thank you. Yep.
Those actually, there were prior that it hits that for the first time.
Did they,
They're in the indictment.
Dalton Batiste? Guess Tom's already gone.
They went back to.
Would you grab Tom real quick and make sure? Would you send me back one of the rejections?
It's in the indictment.
Did you go over with him, the enhancement at first? You've gone over that and explained. Since I didn't do it on the record, I want to make sure that's been done. Okay, perfect. Thank you. No, ma'am, I'm good. Mr. Rojas, you've got, Jamon Adams. Good morning. Are you Jamon Adams?
Yes, ma'am.
And Mr. Adams, in cause number 26, DCCR 0744, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon. And that's from April 7th of 2026. And what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that you signed with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 5-year term in prison. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
All right, we'll get that done. Mr. Adams, Mr. Rojas is your court-appointed attorney at this point, and he's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, Mr. Rojas, you're released. We'll appoint someone today. They should be out to see you very soon to begin preparation for trial.
Okay.
All right, you can go back with the bailiff.
Can I ask you a question?
You sure?
When it comes to the next lawyer, will I be able to tell you what really happened? Because the last time I heard.
So you just need to talk to your lawyer about that.
Okay.
That's who you need to tell everything. And then he'll talk to the district attorney and that's all kind of between you guys, not necessarily me, okay?
Yes, ma'am.
All right, you can go back to the bailiff. Linton Alexander.
Alexander.
Good morning. Are you Linton Alexander?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Alexander, in cause number 26 DCCR 0601, the state has elected to proceed on the lesser offense of a third-degree felony attempted burglary of a habitation from March 12th of 2026. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Also, do you understand if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Alexander is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of the third-degree felony offense of attempted burglary of a habitation, sentence you in accordance with your agreement to a term of 5 years in the institutional division.
Should be 4, Judge.
Judge, I think, actually, I know, it originally was 5. Maybe Mr. Ross accidentally wrote 5. We talked about it when I reduced it because the offer was 4. It should have been 4 the whole time. If I didn't catch it, that's on me.
Nope, it says 5.
It's 4,
But
yeah.
I'll
I'm sorry,
check.
Judge. It's supposed to be.
That's okay.
Trying to give you- It's cool.
Hold on, let me,
Yeah.
with everybody's permission, I
We
can change.
still catch it.
All right, so I'm going to sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition or about how long that lasts, you can talk with Mr. Rojas. All
Okay.
right, good luck to you, sir. You can go back with the Bailey.
Thank you, Your Honor.
Thank you. Justice Larzo. Oh, yeah, okay, thank you. And it's just, we don't have anything done or, yeah, we're just gonna. Good morning, are you Justice Larzo?
Yes, ma'am.
And Mr. Larzo, in cause number 26, DCCR 0770, you're charged with the third-degree felony offense of obstruction or retaliation from March 8th of 2026. Your indictment alleges that you were previously convicted of assault on a peace officer and assault on a public servant on October 12th of 2023, both of those cases on the same day, which means if you go to trial and are found guilty in these cases, or this case, and those prior offenses are true, that means you would be considered a second-degree felony for punishment, which is between 2 years up to 20 years in prison. Do you understand all of that?
You can repeat that for me?
What part of it do you not understand?
The first part,
What you're charged with?
the part where you said.
So here's the thing. You're charged with obstruction or retaliation.
Correct.
The offense date is March 8th of 2026.
Correct.
And that's a third-degree felony.
Correct.
The indictment also shows me that you were already convicted of 2 other felonies on the same day. What that means is if those are true, or at least one of them is true, it would enhance your punishment in this case to a second-degree felony, which means if you go to trial, you're found guilty, the range of punishment is between 2 years and up to 20 years instead of 2 to 10. Do you understand? Sure.
What it says is if you convicted, if you catch the case, 2 of the cases at the same time, then that would be consist of the enhancement. If you put both of those charges at the same time, I didn't catch those charges at the same time, even though I was convicted at the same time because they ran the CC.
Here's the thing, it only matters on one of them, right? Because the fact that they were run CC is what makes this enhanced by 1 instead of turning it into a habitual. So I'm only counting it like it's 1, right? So let's just assume you have 1 prior conviction. It doesn't matter if you have 1 or 2 or 14 from the same day, the same conviction day. It only will enhance this 1 level, which means from a third degree to a second degree, just like I said. Make sense? Okay, so.
I'm sorry to interrupt,
Sure.
if I may.
Yes.
For the benefit of the defendant, I've tendered that pen pack to Mr. Rojas. The convictions are on the same day, but for the actual same type of offense. And in this instance, he threatened to murder a police officer, which is why the offer is what it is. And for his benefit, I also tend to introduce a punishment where available by the rules of evidence, the misdemeanor and juvenile contacts with the law that he has had as well.
All right, thank you, Ms. Malfino. So you've had an opportunity to visit with Mr. Rojas about your case. And Mr. Rojas, do y'all have an announcement?
Judge, I was speaking with Mr. Larzo yesterday. I think his intention is to come here this morning and ask for a new lawyer. I explained to him the way to get a new lawyer is to reject the offer and set it for trial, because I think that was originally his intention. He, however, didn't want to sign any paperwork with me.
Because I haven't got an offer. You haven't gave me an offer. You said 5-year cap. I don't know what that is. That's not an offer. If you offer me 5 years TDC or you offer me 5 years probation, you didn't say which one. So when I get an offer, I'll let you know. I don't know what the offer is.
Sounds like the offer was a 5-year cap. Is that correct,
That's the
Mr.
offer.
Rojas? And I'm sure Mr. Rojas explained to you what a cap is.
Yeah, he just said I can't get more than 5 years.
Right.
Okay, so what is the offer? How many years? 5 years TBC?
So it's up to me. So if you sign for a cap, and I'm sure Mr. Rojas explained this to you, it's a way for you to try to come to me and say, give me less than 5. I could give you 5, 4, 3, 2, or I could consider probation. It would all depend on the information that I received at a sentencing hearing. But if I follow the agreement, I couldn't give you more than 5. So it's something where it's not for sure. You have an opportunity to ask for something within that range. Does
I'm
that
trying to handle this today.
what?
I would like to take care of this today.
Well, talk to your attorney and listen to what he has to say. And if y'all want to take care of it today, then there's some paperwork that you have to go over with and sign, and then we'll go forward. All right? You can go back with the bailiff. Joey Mink.
Joey, me.
The paperwork on this one. Oh, I don't have it yet. All,
Didn't send me.
Yeah.
Not for your sake.
good morning. Are you Joey Mink?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion in each case?
He will, Your Honor.
I'm gonna need,
And Judge, I'm going to give you a heads up on this. The motions were, you're going to shake your head if they don't match up, or if they've been administratively difficult, for lack of a better.
let me get them printed out real quick and we can all be.
At one point in time, the probation department only wanted 1 filed, and then the clerk asked why there wasn't 2 filed, brought that to my attention. So I filed the second one. So if there's errors, I apologize in advance.
So we'll just start with the first one. There's Mr. Mink in cause number, and he'll waive the formal reading in both.
He will.
Okay. So Mr. Mink, in cause number 23 DCCR 1851, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for the 3rd-degree felony offense of evading arrest or detention with the use of a vehicle. And that was a 4-year deferred probation. Is that correct? And in cause number 24 DCCR 0294, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation July 1st of 2024 for aggravated assault with a deadly weapon, a 2nd-degree felony, and that was a 6-year deferred probation. Is that correct? Both of these cases allege that you violated your probation. Count 1 in each case alleges that you violated the special amendment requiring you to successfully re-enter the SafeP program. And is that true or not true? True or not true? And then in cause number 24 DCCR 0294, that motion also alleges in count 2 that you failed to provide verification of performing the community services required. Is that true or not true?
True.
And count 3 in that case alleges that you're behind in your court assessed fees. Is that true or not true? Did you enter your pleas of true to all of those counts freely and voluntarily? And did you plead true to them because they're actually true? In both of those cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal? State tenders number 1 in each case?
No objection, Your Honor.
It's admitted in each case. And is the punishment the same?
Yeah.
Okay. All right, I'm going to find in each of your cases that you entered your pleas of pleas are true to counts 1 in the one case and then 1, 2, and 3 in the other, freely and voluntarily. Find all of those counts true. In cause number 23, DCCR 1851, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a motor vehicle. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 24, DCCR 0294, find counts 1, 2, and 3 true. Find sufficient evidence in that case to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 4 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon in that case. The two cases or the two sentences will run concurrently, which means together at the same time. I'm going to hand you in each case the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff.
Okay.
Just that one?
Yes, one.
Thank you. Let's see, Kashonda Riley to sentencing.
This courtroom hearing became a powerful reminder that second chances only matter if someone chooses to change. The defendant stood before the judge asking for probation instead of another jail sentence, while her attorney explained the painful circumstances that had shaped her life. Growing up in foster care, having parents in prison, and struggling to find stability painted a heartbreaking picture. For a moment, it seemed the court might focus on her difficult past. She spoke about her children, admitted her mistakes, and promised she wanted to rebuild her life. It was an emotional plea that could have earned sympathy from almost anyone in the courtroom. But the judge looked beyond the emotions and focused on one crucial fact. This wasn't the first opportunity she had been given. The court noted that she had already received probation multiple times, yet continued committing theft offenses shortly afterward. Instead of seeing progress, the judge saw a pattern of repeated choices. The judge's message was direct and unforgettable. If you want a different future, you have to stop making the same decisions. She reminded the defendant that every new offense brings harsher consequences, and breaking the cycle is ultimately a personal responsibility. In the end, the court sentenced her to 15 months in state jail, with the sentences running concurrently. It was a difficult outcome, but one the judge believed reflected both accountability and the repeated failure to take advantage of previous chances. This hearing serves as a powerful example that while the justice system may offer opportunities for rehabilitation, lasting change must come from the individual.